joining me. Welcome to my live. And if you have a question about immigration, about your case, about what's going on right now, any new updates, go ahead and leave me your question in the box below, and I'll do my best to answer as many questions live that I can during the time that I have today. And if you would like a case evaluation, you can give us a call at 212-248-7907. All right. So let's go ahead and get right into it and to see what sort of questions that you guys have on your mind. Jamaican girl, thank you so much for your comment. Thank you for your service. It's my pleasure. This is my life's calling to help you to do immigration cases. And let me talk a little bit about why I do love what I do and why I believe in what we do so much. I actually believe that immigration is a human right. So without politics, immigration is a human right, okay? Immigration is a human right, and of course we must observe laws and do things as we can with what is provided to us, but immigration is a human right, okay? And anyway, that's all that I'll say about that right now. Krista X, hello, do we do Vawa? Yes, we do actually. Vawa is our main case type along with T visas. Also, we do U visas, and we do marriage green card cases right now as well. All right, let's see what other questions. And go ahead and let me know what state you're in, what country you're from. I always love to see where my followers are from. Okay. Can I travel with a Form I-51 stamp to Africa from Sana? Sana, yes. If you have an I-551 stamp in your passport, that means that is your proof of being a lawful permanent resident. Usually, people will get an I-551 stamp in your passport if you have a conditional green card that is expired, or if you are waiting on a renewal of your green card. So as long as you have that and it's valid, you should be okay to travel, but always check this with your attorney first. Can I do adjustment to status entry? Can I do an adjustment to status application without a visa from S23? The question's a little bit unclear. So if anybody wants to do adjustment of status inside the US, adjustment of status is the actual application process through which you can apply for a green card. And do you need to have a visa to apply for adjustment of status? And the answer is not necessarily. However, there are some key differences to who is able to do an adjustment of status I-485 green card application. So if you are filing for a green card through marriage, through your 21-year-old child sponsoring you, through being the spouse of a U.S. citizen, you need to have a lawful entry into the United States. You need to have proof of lawful entry into the United States, because for these cases, a proper admission with entry is required. However, there are lots of people who do not have a lawful entry. So what option do you have? If you do not have a legal entry to the United States, there are still some case types that can allow you to get a green card in the US by filing the Form I-485 and doing adjustment of status without having to leave the US. Because ultimately, people do not want to leave the US, because if you get stuck outside, if your case gets denied at the consulate, who knows how long you'll be separated from your family, and it can be very, very risky. So what are the types of cases that you may be able to do while being here inside the United States without having to leave? Let's talk about this right now. I'm going to go over two not so well-known cases or case types that are not actually that common, just to get it out of the way. The first one is going to be Section 245I adjustment to status. Let's just say that you have an adult U.S. citizen child or a U.S. citizen spouse that wants to sponsor you, but you don't have a legal entry. However, you recall that back in the day, way back when, maybe an employer tried to sponsor you, or your parent or your brother or sister tried to file an I-130 for you. Well, did you know that if they actually filed that I-130 or an I-140 or a labor certification application before April 30th, 2001, then you may be protected underneath something called Section 245I adjustment to status. Well, what that would do is that you pay an additional penalty, and it allows you to file an adjustment to status application even if you don't have a lawful entry to the United States, as long as you pay that fine and you show proof of something that was filed before April 30th, 2001. However, this is like finding a needle in a haystack, so it's not very common. However, it might still apply to you. So you have to look around to see if this might apply to your family member. The next is going to be military parole in place. So for those of you who are spouses of whether your spouse or your parent or your child is has served in the US military, they may be able to ask for something called parole in place for you. And it does the same thing. It basically takes that unlawful entry and kind of erases it, kind of pushes it to the side so that you can go ahead and file your I-485 application to adjust status without having to leave the US. However, there is something very, very important for you guys to know about these two case types. If you have something called a permanent bar, then you would not be eligible to do military parole in place or to adjust your status through Section 245I. And what is the permanent bar? Well, the permanent bar is going to be one of the most harshest, strictest immigration penalties that is imposed upon a person for basically re-entering the United States multiple times, okay? And I'm not gonna go ahead and talk about it right now. I'll talk about it in just a little bit. So let's go on. If you don't have a lawful entry, how else can you get a green card in the US without having to leave? Well, if you are married to a US citizen or to a green card holder, or if you are the parent of an adult US citizen child, where one of these relatives has been abusive to you, whether that abuse is emotional, or physical, then you may qualify to do something called a self-petition through Vawa. Now, this is something that we deal with a lot in our office. Now, when it comes to spousal abuse, if your spouse is hurting you, it's something that is actually much more easier to understand for a lot of people because abuse from your spouse can be mental, it can be emotional, it can be psychological, it can be verbal, it can be financial, and it can also be sexual or physical. So for example, if your spouse is constantly putting you down, if your spouse is the jealous, controlling type that doesn't let you go certain places, let you wear certain things, appear a certain way, talk to certain family members, talk to certain friends, and they are just trying to control certain aspects of your life. And on top of that, they're a US citizen, so you might feel even more compelled that you have to obey your spouse, otherwise there's going to be a problem with your application, or you are literally afraid that they're going to cancel your case or not show up to the interview. Then these are pretty good signs that you may qualify for something called VAWA. And through VAWA, you get to file for a green card application as well as a work permit and travel document if you are eligible, okay? And this case type takes about 3.5 years to process. And a lot of times we are getting the green card approved with 0 interview, okay? Now this may change, of course, in the coming years, but right now we see a very small percentage of our cases get an interview. And so that's VAWA self-petitions. Now, if you are the parent of an adult US citizen child and you don't have a legal entry to the United States, but your child is basically somebody who has given you a lot of trouble during your life, no matter what you have done to raise your child's right, then this may also qualify for a VAWA self-petition too. And we actually just got another parent VAWA approval today for a case that I filed in 2020. I can't wait to call my client for that. And the thing about the VAWA self-petitions for parents that I want you to understand is that parents have a really hard time accepting VAWA or to accept that maybe their child has been the rebellious type or the type to give problems. But I want to let you know that in all the parent VAWA cases that we have had approved, we have seen a variety of behaviors from the child to the parent. And I want to give you some examples. If you are the parent of an adult US citizen child, meaning that your child is at least 21 years old, and your child has done things to you like as an adult after the age of 21, if they have done things to you like play mind games on you, tell you that you're a bad parent, shame you for being from back home, they tell you to go back home, they bring up your immigration status, they curse at you, they scream at you, they break things or throw things around in the house. And the question that you should ask yourself is, are you afraid to get your child upset? Are you afraid to get your child upset because of what consequences that you may suffer? Maybe they will humiliate you in front of other family members. Maybe they will break things. Maybe they have even threatened to call immigration or get you arrested. Believe it or not, these things do exist. And also, in addition, if your child has actually laid hands on you, like sometimes there could be fights inside the house where you get pushed or shoved, these or get things thrown at you, and these all count as actual abuse, okay? And we have gotten so many cases approved for our parents, and for those of our clients, especially my clients from Mexico who have been here for 20, 30 years without ever going back. This is one of the cases that I really love to look for in clients, okay? And for this, you do not need to have a legal entry either. And in many cases, if you have the permanent bar, we might be able to get it waived through this case as well to help you get a green card, okay? Now, the next case where you don't need to have a legal entry to get your green card is something that I particularly love to do. It is called the T visa. Now, the T visa is going to happen in a few different ways. Number one, if you have actually worked for somebody, whether it's a business or it's a one person that you worked for a period of time, if that person did not pay you properly, threatened you, you were scared of them, you were basically, you felt like you were basically, I don't even know how to say it right now, but if you were afraid of not listening to your boss and the consequences that you would suffer, for example, if your boss, if you were afraid to not do as your employer said because you were afraid of getting humiliated, punished somehow, maybe getting wages deducted, punished by not being able to leave at a certain time, punished by literally through physical force. If your employer did things like that to you, if they brought up your immigration status and made jokes or implied that you might get in trouble if you don't listen to them, these may be signs that you qualify for something called a labor trafficking visa. So that is one way that the T visa may be possible. The second way could be if you were in a relationship with somebody and instead of you being an equal in this relationship, you were treated like a servant. You had to cook and clean and do the chores and serve your partner no matter what time of day it was. And if you didn't serve them, then you might be punished with violence or something else. This may also lead to a T visa. And the next way that a T visa may be possible is if you use the services of coyotes to enter the US and the coyotes made you do things, right? Made you do unspeakable things, made you work for them, made you provide certain services, then this may also arise to the level of a T visa as well. And the beautiful thing about a T visa, I like to call it a miracle visa because it helps to waive so many immigration problems, including permanent bar, unlawful entry, and even having a removal order as well, okay? And the last way that, the next two ways are much more well-known that you probably have already heard about. The U visa and Asylum are other ways to get your green card without having to leave the US. However, these take a long time right now. I'm not even going to go into it, okay? All right, and if you do want a case evaluation, you can give us a call, 212-248-7907. Okay, let me get back to questions. Traveling in advance parole is okay with I-485 pending. I'm going to let you guys know right now that we in our office have advised all of our clients to not travel on advance parole for the next couple of months until we see what happens with the Trump administration. T visa, waiting for receipts is safe from Hardik Patel. Hardik Patel, okay, so here's the thing. If you are waiting on receipts or your case is not filed and you're wondering, are you going to be safe? The answer, the real answer is that the receipt itself, even if you have it, may not always prevent you from being arrested if you have ICE. But if you do have a case that is waiting for receipts, you can still, if you do get stopped by ICE, you can still try to show some proof that you have a case filed. I would recommend getting a letter from your attorney to show that these receipts are being waited for. That may be of some assistance. Can Vawa be filed only when the harassment is done when he is a green card holder from Indian Red Horse? Absolutely. As long as your spouse is currently a green card holder right now or a U.S. citizen, you can file for Vawa. It doesn't matter when the abuse happened, as long as the abuse has happened during the course of your relationship. I got a prima facie from Vawa. It took 10 months. How long to get my work permit from Dedusus? So work permits will usually take about, I would say about 8 months average through a Vawa case if you're waiting on an I-485 work permit. But if you did not file an I-485 with your Vawa application, you're waiting for a work permit, then you would basically wait till your Vawa is approved, which could take more than 3 years. Ayala Corona, if HR 875 passes, will be retroactive. Corona, I actually don't know what the text of HR 875 is. How long does the T visa processing time take? So T visas are taking average about 1.5 years currently for USCIS to decide. Now, of course, this can go up, this can go down over the next couple of years. All right, let's go ahead and answer some questions from YouTube and Facebook. Sorry, guys, see that you've left a lot of messages already. Can I be deported if I have an I-797, basically a receipt from Miguel? Miguel, so a receipt by itself may not protect you completely against deportation. However, it can be used to try to, if you have a case that's pending, sometimes that could be persuasive to DHS to stay your case, to stay your removal, or to basically not, to decide to not bring a notice to appear against you. Tamar from Tennessee, hello. Do you represent immigrants who reside in Buffalo? We actually represent clients all over the United States. So it doesn't matter to us where you're from, as long as you are willing to work with us and we can take your case, then we'll represent you wherever you are. I filed for my wife. She has her social security number and working papers from USCIS. Should be okay even if she has overstayed from Kerman. Kerman, it sounds like your wife has an application in progress and she also has a valid employment authorization document, or EAD. And if you have an EAD, then this is going to be basically like a physical proof. You know, it's a federal ID also, right? So you can, if you do get stopped by immigration, then you can show your EAD as long as it's not expired as proof of your current status. And if you have a case in progress, then that will probably help as well. Ashwani, I have one question. I married a U.S. citizen and did not have any pending case. I have no status. If they caught me, can I tell them I'm preparing Vawa? What to do? Ashwani, yes. If you have a Vawa, if you are in the middle of filing for an immigration application, even if it's not filed, if you do happen to get arrested by ICE, there are certain ways that can be that could still be used to help get you out of basically help as provide some sort of relief in removal case. So hopefully that helps, Ashwani. Do we do face-to-face consultations? We do not. We offer case evaluations through the phone and sometimes by Zoom if you would like it by video. What is the timeline for EAD for pending I-485 based on a T visa? From Rashi. Hi, Rashi. I don't have the answer for that. If you are filing an I-485 and an EAD request with that, then usually it can take from 8 to 10 months. But the timeline for an I-485 that is attached to a visa is not always going to be the same as an I-485 and I-1, an EAD based upon an I-130 or a Vawa. So I don't really have the exact information on that. Where are we located? We're located in New York City and we work with clients all over the US. And if you do want a case evaluation, you can give us a call at 212-248-7907. Our case evaluation fee is $150. And if we do take your case, then we would actually apply it as a credit to your case. Okay. Anthony, thank you so much, Anthony. Moumita and her team helped me get my working permit, social, and a permit to travel abroad while I wait for my permanent residence program. Anthony, so much. Thank you for your review too, Anthony. I really appreciate it a lot. Sandrine, I have a question. Is there any way someone who has never had a green card but has asylum for 5 years, can they just become a citizen? From Sandrine. Sandrine, if you have asylum, first of all, congratulations on your grant of asylum. For you to become a citizen, you first have to obtain your permanent residency. And anyone who obtains asylum can file for permanent residency after being an asylum holder for at least 1 year. So if you've already had asylum for 5 years, you filing for your green card is long overdue, Sandrine. So you should go ahead and do that first. Once you hold your green card for 5 years, then you can apply for a citizenship. If you have a pending appeal with the Board of Immigration, are you safe? That's a good question. It depends on what you're appealing. It depends on what case posture you're in. But generally speaking, if you do have an appeal pending, then it can, again, so the overriding question is basically that's on everyone's mind is that if you have a case pending with immigration, will that protect you against deportation? And the answer to that is going to be basically it's going to boil down to a maybe it might help. Okay, it's not a definite yes that it will help, but it's a maybe, because what will happen is that if you do have a case that's pending, then that is essentially going to kind of almost like lower your priority for removal. However, it's not a guarantee, because it's also going to boil down to the ICE officer and the ERO agents basically that are processing your case about what they want to do as well. So it could help be persuasive to release you from detention sometimes, or to basically stretch out your case, or sometimes get it closed. Or maybe it might persuade them to not even bring any charges against you for removal. It's going to come down to like basically case by case basis, okay? But if you have an appeal with the Board of Immigration Appeal, then technically that's a little bit different, because when you have a appeal pending with the Board of Appeal, if it's from a judge issued decision, then that may help, and you can also file for something called a stay of removal. If your appeal is coming from a adverse decision from the immigration judge. Now, if you're appealing something else, then also, again, like it might be persuasive, okay? Can someone apply for citizenship with a dismissed misdemeanor from brains not emotion? Brains not emotion, if you have something that is totally dismissed, then that means that there's no conviction. But a lot of people confuse, you really have to have an attorney take a look at your criminal documents, because a lot of times people think that they had charges dismissed when in reality it was downgraded to a lesser charge. So if you have any sort of criminal history at all, even if you think it got dismissed, my recommendation is for you to discuss your charges with an immigration attorney prior to getting your application filed. And actually my further recommendation is for you to actually use the services of an immigration attorney who has experience with criminal matters, so that your application is filed properly. Because as I mentioned, a lot of people think that sometimes their charges were dismissed, when in reality you may have taken an admission to a lesser plea, which would still count as an admission that might cause you problems, even if it's a misdemeanor. Thank you for sharing my live, Hannah. How long will OPLA take to respond after you submit a PD in New York City, Vawa proof from Jack? This is a great question. It depends. If you are in removal proceedings, or if you have an order of removal and you have an approved I-130 or an approved I-360, and you're trying to get OPLA or the Office of the Principal Legal Advisor, basically they're the lawyers for ICE. If you're trying to get the lawyers for ICE, DHS counsel, to reopen your case, then that is going to take, if you're trying to reopen your case with OPLA because of an order of removal that you may have received years ago, they have literally said to expect for that to take at least a year. Okay, they say at least a year for that to happen. Now, if you have an active case on the court docket, if you have hearings coming up in your case and you submit a request for prosecutorial discretion to DHS to ask them to terminate or dismiss or to admin close your case, then because of the very fact that your case is still active and you have hearings coming up, you will probably hear back on your request for prosecutorial discretion closer to your hearing date, because they are very busy and they're not going to look at requests. They're not going to make any decisions on a request until basically sometimes even the day of your hearing or the day before. Okay, so that's about how long it takes. I'm in the military. My wife doesn't have an I-94. Can I apply for her? From Matumbo Balombo. Matumbo, if you're in the military, if anyone here is in the military and they want to apply for their spouse, whether your spouse can benefit from you being in the military or not is going to depend on their own immigration history. If they have really just that one unlawful entry, then you being in the military can help your spouse get something called military parole in place, so that they can later apply for a green card in the US without having to leave. But if your spouse has problems like the permanent bar, then that is going to be an issue. If your spouse has any sort of fraud issues or criminal issues, and they might need a waiver. Being in the military by itself will not take care of all that. There's going to be additional applications that need to be filed. What if my asylum is not granted, but I have a master hearing? Can I apply an I-130 from Prashila? Prashila, well, if you are actually legitimate, you have a bona fide marriage, a good faith marriage to a U.S. citizen, even if, you don't have to wait for your asylum hearing, or you don't have to wait for your asylum case to be denied. If anyone here is, has a legal entry and they are waiting for an asylum hearing, but they're in a bona fide good faith marriage, that means that you married your spouse for the sake of having a marriage and not just for papers, then I would recommend that you get your I-130 filed sooner rather than later. Now, what happens though, if you have a case in court, but you don't have a legal entry and you are married to a U.S. citizen, then what can you do? Well, there's a couple of things you can do. Number one, I'm always going to recommend that you get yourself evaluated to see if you have suffered anything in your marriage that might qualify you for a Vawa self-petition. Because again, with a Vawa self-petition, you do not need to show proof of legal entry, and you do not need to rely on your spouse. And a lot of times what I see is that if you're relying on your spouse, there can be a lot of issues where they don't want to give you tax returns. Also, they might want to cancel the case on you later. So I think it's always good to get independently evaluated to see if you might qualify for a self-petition first. And if that does not appear to be a reasonable possibility for you, then if you are going to do a joint case with your spouse, you don't have a legal entry to the United States, and you have a case in court, here are a couple of scenarios that might work for you. Number one, you should be able to file an I-130 right away. And once that is approved, you can ask OPLA to agree, for a joint motion to dismiss on your case. If your case gets dismissed, then you can pursue an I-601A waiver and leave the U.S. for an interview at the consulate in your home country. Or you can actually, once the I-130 is approved, you can ask the court to do an administrative closure, so you could do the same thing, okay? And if that is not something that you want to do, then the second option would be to get yourself evaluated for something else. Like maybe you might qualify for a T visa or a U visa, or as I mentioned previously, for a Vawa self-petition, okay? If you want to give us a call, Priscilla, 212-248-7907. What if your boss refuses to give you a 1099 form from Sparkles? Sparkles, I guess I would need a little bit more context. Like a boss refusing to give a 1099 does not necessarily constitute abuse, I would say, or something that could help you in your immigration case. What do you think will happen with TPS in Venezuela from Evergreen? So I believe that TPS has already been announced to be no longer, basically canceled, right? So I don't think that this is something that, I don't think that this administration is going to do anything helpful for persons from Venezuela. That's my opinion, actually. I'm married to a green card holder. How long will it take if I overstay my visa from Priya? Priya, this is something very similar. If you are married to a green card holder, but you overstayed your visa, you're not going to be eligible to do adjustment of status because you are out of status and you have unlawful presence. But there's two options for you. If you are married to a green card holder, but you overstayed your visa, the first option is you may be able to do an I-601A waiver and leave the United States to process overseas when your priority date is current. Or the second option would be to actually wait for your spouse to naturalize and become a U.S. citizen, and that way you'll basically be considered an immediate relative and you don't need to leave the U.S. and you can file an I-485 and I-130 right away. So you might have two options, Priya. Depending on which one you choose, that will dictate how long your case takes overall. If asylum case is dismissed by judge in court, can I adjust status to student visa? From Ken. Ken, judges are not going to dismiss an asylum case. They're either going to approve or deny it. So if your judge denied your asylum case, then you're out of luck. You're out of luck. If your judge approved your asylum case, you don't need to change your status to a student visa. So I'm a little bit confused by your question. But if your case got denied for asylum, then you can't really apply for a student visa because you're out of status at this point. Brenda G, what if it's expired, but I already paid for my work permit from Brenda G? Brenda G, I'm not too sure where the rest of your question is, so I'm not sure how to answer it. Okay, can I travel from Orlando to New York on the train on a pending case with my driver's license from to desk control? Okay, this is a question that we're getting a lot from current clients as well, and just from the public in general. If you have a driver's license, an unexpired driver's license, can you travel interstate? Can you travel domestically interstate, whether it's by train or driving? Can you travel interstate domestically if you have a valid driver's license but no legal immigration status? And the answer is going to be that, well, it depends on what your tolerance for risk is. If you really desperately need to travel, you have an emergency, but you have a valid driver's license, I would say that, like, can you maybe arrange to have somebody else drive? Because if you yourself are driving and you happen to speed or get pulled over for something, then you're going to be a little bit more of a bullseye, right? So if you're at least going to travel, can you try to arrange for somebody else to do the driving? But then again, if you get pulled over in a state where they're questioning you about your immigration status, even as a passenger, that may end up causing a problem for you and cause you to get questioned and possibly detained. If you are flying interstate, as far as I'm aware, TSA is not asking for proof of immigration status, but you also never know when ICE is going to be present and questioning people about their immigration status, okay? If you're taking a train, same concept, a train or a bus. Generally, you're not driving. They're not asking you for proof of immigration status to board. But if ICE happens to board the train or the bus and questioning you about your immigration status, then that can pose a big risk for you, right? Now, I just want to go over real quickly what to do if you are stopped. If you're in a public area, such as a train or a bus or outside on the street, and an ICE official encounter an ICE official, and they ask you about your immigration status, what are your rights? What are your rights? What should you do? How can you protect yourself? Now, at the end of the day, I want to make it clear to everybody that if you are undocumented, you don't have legal immigration status, and you get stopped by ICE in a public area, even if you exercise your right to remain silent, you can still get arrested. Even if you exercise your right to not provide any documentation, you can still get arrested, okay? So, however, you should still exercise your right to remain silent. You can ask them if you're being detained. If they say no, walk away. You are under no obligation to remain standing to answer questions. If they say yes, you're being detained, then you simply say, well, I decline to answer questions. I'm exerting my right to remain silent. You can say these things. There's going to be a lot of intimidation and fear tactics that will be applied against you to get you to say things. But the purpose of remaining silent is not to prevent you from getting arrested, but it is actually to prevent you from inadvertently giving them evidence that they can then use to remove you from the US, okay? That is the purpose of the right to remain silent. The purpose of the right to remain silent is to prevent you from incriminating yourself. The purpose of not producing your documents, if it's a foreign passport, especially, is to not make their job easier in deporting you from the U.S. because that is something that you have to provide to them. They can't produce your passport, right? They have your passport. They know what country you're from, or you affirmatively say that you're out of status. You are making their job easier for them. These are things that ICE has to prove. These are things that DHS has to prove to remove you from the United States. And that is the purpose of remaining silent. And the purpose of you saying these things out loud is that if they happen to still arrest you, if they still happen to detain you, even after you say you wish to remain silent, basically those are admissions. You can use them in court to challenge anything like unlawfully obtained evidence, for example. So these are the reasons why we want you as a non-citizen to exercise your right to remain silent. And these are the reasons why you should not be just showing your passport, and you shouldn't even be carrying your foreign passport along with you. Now, this is not the same as, like the videos that I've made where I say if you're a US citizen, it might be a good idea to carry your US passport, right? If you're a green card holder, green card holders do have the requirement to carry around their green card and show a copy of their green card, okay? But if you're a person completely without status, these are the reasons why you want to exercise your right to remain silent, okay? All right, and I've lost my train of thought. Emmanuel, if you have a T visa pending, that may not prevent you from being arrested or getting placed into removal proceedings. However, we can still use that. We can still use that to try to persuade them, to negotiate them to release you or to not enter charges against you, hopefully. I hope that helps, Emmanuel. Obviously, the best thing is for it to actually be approved so that we have definitive and definite proof that you have deferred action and protection against deportation. Have you ever seen a denaturalization case from Dale Shand? Absolutely not. I've never seen it. I've only heard of it. It's very rare. I actually did a video on denaturalizations, especially underneath Trump. Please go check it out on my YouTube page. Denaturalization cases were like less than 2,000, I think, underneath the first Trump administration. So it's a very, very small part of the population that will have proceedings entered against them for that. Okay. I'm a current Vawa client of yours. If I get an interview underneath the Trump administration and the immigration officer sees that my case is real, is that an indication is the green card's less than 3 years? From Anthony. Anthony, if you get an interview in your Vawa case, usually it will be for the purpose of the I-485, so it should be after the I-485 is after the I-360 is already approved. Usually they're not, there was a short period of time in December that I-360 Vawas were getting interviewed, but they have not reissued decisions to interview them. But if you have a interview, it's probably going to be for the I-485 at this point, which means that your I-360 has already been proved, basically been approved as being real. What is the processing time for a marriage case? And does USCIS do home visits here in San Francisco? From Ajay. Ajay, I don't know exactly how long it is in San Francisco. However, the processing time for green card cases through marriage, through the regular joint marriage case, is typically 1 year, more or less. Do they do home visits? Absolutely. USCIS does do home visits to determine fraud. They're called fraud investigations by HSI, and it can happen. It's not always that common, but it can happen if they do suspect fraud. Danish Khan, we will contact you regarding your case. Can they stop you if you have a work permit? Yes. ICE is literally stopping anyone they suspect to be an immigrant. So even if you have a work permit already, they can still stop you. However, if you do have a work permit, if you show it to the ICE officer, then typically they're probably not going to do anything to you, and they're going to see that you have a case. Basically, it's proof of basically being in an authorized period of stay almost when you have a work permit. Apple Bottom Diva, the cost of a case evaluation is $150. And again, if we do take your case, then we apply it as a credit to your case. Can J1 visa holder join the military? From no, I believe you actually need to be a lawful permanent resident for that. I have a conditional green card and I got divorced 1 year before my expiration date. From Mustafa, that's a great question. So if you have a conditional green card and you have gotten divorced, is there anything that you can do? And the answer is yes. If you have a tier conditional card and you got divorced or you're in the process of getting divorced, the most important thing that you have to do right away is contact an attorney, because you have to take immediate action. If you are getting separated or if you have already gotten divorced from the US citizen spouse that has helped you get your initial green card in the US, then that means that you're not going to be able to file jointly with them to remove conditions on your card. And you have to prove to the US government that your marriage was made in good faith and that you deserve a waiver either because you have a divorce certificate or because you suffered extreme cruelty or battery during the course of your marriage. And you have to do this sooner rather than later. A lot of times people will wait exactly until their card expires to try to file these applications. And by then you've already lost a lot of time. Time is of the essence when you have this case. And it's really, really important to work with an attorney on this, because if your I-751 gets denied, then usually you will go directly to court into removal proceedings upon denial. And in our office, we have worked with hundreds of super complicated, super complex I-751s. Even we have gotten approved I-751s for people who filed I-751 applications before with other attorneys. Other attorneys got them denied. And my favorite story that I love to tell is that we got a client his 10-year green card through an I-751 after he already got his first I-751 denied with the help of another lawyer who did not do a good job. And the judge denied it too. So he actually got ordered removed from the US. But he stayed here and he found me 10 years later. I said, let's go ahead and file this waiver. I believe that you can win. We filed the I-751. It got approved. We reopened his deportation order. We got that dismissed. And now he has a 10-year green card and is filing for citizenship soon. All right. Momin Abaji, yeah, I think actually, Momin, I did answer a question to Lex this morning or this afternoon already. Mitch, hello. Okay. All right, guys, so that's all the time that I have for today. I want to leave you all with a message because I know that there's a lot of anxiety and fear out there right now with what's going on. Number one, I want you to remember that there is a lot of fear mongering and misinformation out there. While it is true that ICE is in certain locations arresting people, my sincere belief is that there's the reports of this have been inflated and made to look worse because they want you to be scared. I want you to always remember how resilient you are. It takes a lot of courage to leave your country to try to make a better life over here. And I don't care how you got here. I don't care if you got here with a visa or without a visa. You deserve dignity and respect, okay? And if you're trying to apply, I mean, you're trying to fix your status. You're trying to live in security. You're trying to do things as well as you can. The truth is that the immigration laws are written in a way that don't make it easy. So when people say wait in line, it's not always as easy as that. So anyway, I will always, my firm and we will always do our part to take care of our clients. And we will always fight for our clients because we do believe in you. We do believe in you. We do believe that you deserve to have peace and security and stability here. We did believe that you deserve happiness as well. So anyway, this is what I wanted to leave you all with. I want you to hold this tight, and always remember that a piece of plastic does not define your worth as a human being, okay? Thank you so much. Good night and God bless to everybody.